Hello, my name's Osha. I like talking about American presidents. Today I'm continuing with my discussion on President Howard Taft's period as Chief Justice of the U.S. Supreme Court. Now I'm going to talk about one of his infamous cases. It's called Bailey versus Drexel Furniture Company. It was decided in 1922, and President Taft wrote the opinion. Of course, he was sitting as Chief Justice, right? He was Chief Justice of the Supreme Court. Again, President Taft, number 27, is the only president who went on to be Chief Justice of the Supreme Court as well. Now, before I get into the case, it's kind of funny that you'd expect uh, that a personage who uh, not only uh, not only executes the office of president, which is a very difficult job on its own, but he goes on to hold the position of Chief Justice of the Supreme Court of the United States. You'd expect that everybody would consider such a personage as having a prodigious intellect. Someone at par with the intellect or IQ of John Quincy Adams. John Quincy Adams himself, he is the only president who went on to continue in Congress after his term of office as president was over. But however, surprisingly, the historians and psychologists who look at the IQ of U.S. presidents are not impressed with William Howard Taft. And William Howard Taft is scored in the bottom, lowest percentile amongst, you know, U.S. presidents for their in terms of their IQs. Um, he scores just 1 point higher than GW, whom of course most Americans do not think exhibited any intellectual capacity. Uh, but GW scored about 138.5 in the histometric scores on average, while Howard Taft scores 139.5 on average, which is one of the lowest. I think it's even in the bottom. It's definitely in the bottom five, which is rather strange. Of course, John Quincy Adams scores the highest, 175. Now these IQ tests again, they're done, retroactively, and it's even tests today. They've been, you know, experts. They take it with a grain of salt because they're not absolutes, right? They're not absolutes, and they have to be very cautious with respect to interpretation. And but it still gives one an idea, and of course it's also it's a thorny issue again, considering that um, William Howard Taft graduated second in his class at Yale. But this also goes to tell you that your academic performance is it may not uh, say so much about how intelligent or what a genius. Well, first of all, the 139.5, that it reflects high intelligence. Again, virtually all our presidents have demonstrated very high intelligence. The IQ test that I studied for through the histometrics book and studies I read, it was up to George W. Bush. So uh, I wasn't able to see one on President Obama or Joe Biden or Donald Trump. But it ends with George W. Bush, and he scores amongst the lowest as well. And so does Howard Taft. It's interesting, although John Quincy Adams graduated second in his class at Harvard as well, but he does score very high, very highly in the histometrics IQ computation, 175, which is the highest our president has. But you could see from the legal reasoning, right? They had a lot of resources and data to use to study William Howard Taft, especially when he was a Chief Justice on the Supreme Court, which he held for a number of years. Now, this particular case shows the sort of flawed reasoning that causes he makes these flawed arguments, right, which might cause the psychologists doing the histometrics and the historians and those who study American presidents and their intellect make cause them to sort of be critical that that the and they may exaggerate uh, their assessments based on a number of the flawed reasoning which he exhibited as Chief Justice of the Supreme Court. And one of them is in this case. I've studied the case, and it's really, really flawed. It's Bailey versus Drexel Furniture Company, and it's on child labor tax, right? So uh, the case came to the Supreme Court because Drexel Furniture Company was suing the Bureau of Internal Revenue, which, of course, was the precursor of the IRS, Internal Revenue Service, um, for a an excise tax. There was an excise tax which Drexel Furniture Company was levied, and it did pay it, expecting a refund. And so after it filed a lawsuit saying the tax was unconstitutional and it was a penalty um, on businesses that used child labor. Um, so it was um, so the act that allowed the government to impose this 10% excise tax on manufacturing companies that employed used child labor was the 1919 Child Labor Tax Act or law. So so basically, uh, a manufacturing company or business that used child labor. Of course, it gives the definition of child labor as those between 14 or 16 under a certain age. And it gives a definition of it specifies the hours of work that they have to uh, work in order to trigger this tax, the 10% excise tax. For instance, if they worked uh, more than 8 hours a day, or more than 6 hours, a week, then that tax was triggered, right? So long as they were children within this age, under a certain age, between 14 and 16. And of course, it specifies the industries that are affected. And Chief Justice, so Drexel Furniture Company had paid the tax over $6,000, and then he files a lawsuit. Now, Chief Justice, a lower court, of course, first of all favored the company, and then the government took it all the way to the Supreme Court. Now, Chief Justice Taft favored the company, favored the business, ruled in favor, and it was a very infamous ruling. His opinion has been set aside, by the way, but I'm just going to discuss, his argument, and his argument was very, very flawed. It manifests what's called a slippery slope fallacy. It's a very basic reasoning fallacy that you learn prior to going to law school. By the way, I mean I took time to study logical reasoning, it's symbolic logic, and just took time because I was very interested in it. And but this is even like very basic. It's a very basic reasoning fallacy. It's not even something complex. And so one reading his opinion would be so unimpressed. that it's coming from the desk of the thoughts, the mind of the Chief Justice of the Supreme Court of the United States. Um, so Chief Justice Taft, he does uh, several things, right? He says that he explains why there should be a tax, right? The reason for taxation. Taxes are used to raise revenue to, for the government's activities. But he argues that, well, this was a penalty and it was that the government's real intent was to criminalize child labor. And so it was, and then he raises issues of scienter. Scienter just means criminal intent, which comes up in criminal law. So he goes into things like this. And it's not clear why he's raising issues of scienter and things like that. It just didn't seem very clear. But by the way, again, his reasoning, the argument, this Bailey case has actually been overruled by one case, other court cases. One of them being was it Carragher? One's also Marchetti. So they've overruled that through the courts, and especially through a another act of Congress. Right, Congress eventually passed the Fair Labor Standards Act of 1938, of course, under President Franklin D. Roosevelt, who was very labor friendly and who kicked out the very primitive, archaic, labor conditions that still were extant under Chief Justice Taft, who sort of was green lighting the use of child labor. Um, so the Fair Labor Standards Act of 1938, that's what established a minimum wage. It established a minimum wage, and it also established, you know, time and a half for work over 40 hours. And also, it sets the number of hours one could work, uh, and also it established, it prohibited child labor, which was the issue here. It prohibited child labor, right? And so uh, it basically overruled this protection, uh, of child labor, which Chief Justice Taft was doing in his ruling. Um, and let me say what it was that he did and explain how it was such a big slippery slope reasoning fallacy, right? So Chief Justice Taft goes on to talk about how, um, he was saying that Congress did not have the power to regulate manufacturing within the state, that this was within the purview of the state. Manufacturing within uh, the state was actually within the control and power of a state. Um, and he was citing the 10th Amendment. Of course, the 10th Amendment states that um, if that power is not uh, provided to the federal government in the Constitution, of course, or prohibited specifically, to the states, are reserved, to the states respectively, or to the individual. So he was citing the 10th Amendment. Um, and then he goes on to say that 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 the excise tax that Congress was imposing was a penalty, and it wasn't really a tax. That it was a criminal penalty. In fact, he used that term. It was a criminal penalty uh, because of child labor. That Congress was really trying to address the issue of child labor, and it was that the tax was a criminal penalty on businesses, that manufacturing companies that were using child labor, which is true. But the thing is, um, he he something he does wrong is that that's actually within the purview of Congress, right? It's within the purview of Congress to tax. That's in the Constitution. Congress, one of the powers of Congress is to tax, right? And the other thing is, um, Congress also has power to regulate commerce, right? It's one of the powers of Congress to regulate commerce. And there's something what's been argued, which is called the is it the substantial test, right? The substantial test, right? Um, Even activities, economic activities that are occurring specifically within a state, so long as there's a stream and it substantially impacts interstate commerce, then Congress has the power to regulate that activity. So, uh, Chief Justice Taft had been contending that Congress didn't have the power, right? It was unconstitutional for Congress to regulate manufacturing within a state. And he was misapplying the 10th Amendment, saying, well, that this was not something it's not a power that's been given to Congress in the Constitution, and therefore it's reserved to the states, which is inaccurate because there's a commerce clause, right? Congress has the power to tax, that's one, and then Congress has the power to regulate commerce. And of course, it's a bit complicated, and that's why these matters had to be decided in courts, and they were actually settled in later court cases in the 1940s. That's Congress's ability to regulate things like manufacturing and even interstate commerce. Interstate commerce, so long as uh, it can affect interstate commerce or the stream of manufacturing or economic activity. For instance, even if one were just a wheat producer in their home and they're not they don't plan on transporting the wheat to another state, it still affects interstate commerce substantially if the process of manufacturing wheat in your own, producing wheat in your own state, in your own home, affects the price of wheat, right? The issue of supply and demand. If that can affect the price of wheat, uh, it affects interstate commerce and goes through uh, the substantial whatever standard test, and Congress can regulate that. So eventually, ultimately, it turns out that yes, Congress does have the power to regulate uh, intrastate manufacturing, right? So, sort of controverting what uh, Chief Justice Taft was saying. Now, what was a little bit more thorny concerning Chief Justice Taft's reasoning was he went on to talk about how the duty of the court was to abide by the highest law of the land, which is the Constitution. And he said even if it disfavors legislation which is for the good of the people, right? Which is bizarre because the Constitution, one of the purposes of the Constitution is to enact laws for the general welfare of the people, for the good of the people. So again, right off the bat, he's contradicting the goals of the Constitution with his own words. Um, and so, but that was not where he ended. He goes on to now say that he concludes that when that this very specific law regarding child tax, uh, if it's allowed to be constitutional, then it would go on that it could. Even he didn't even say would. It could. So probability issue that that it's something that could or might not even occur. We don't know, right? So he says it could go on and allow the government to start regulating, carving out spheres of influence and regulating and enforcing subjects and using tax to regulate different public interest matters within the state that shouldn't come under the purview of the government in the first place, right? So that's what you call a slippery slope fallacy that I was talking about in the beginning. When you say, well, if you do this, then it's going to create this chain reaction, this domino effect that you don't really know, and you're saying, well, if you do X, that Y, Z, all of these other things that you are not actually dealing with right now, that this specific thing is not dealing with, that those things can subsequently occur, right? They can be triggered. There's a possibility, not the possibility. In fact, in this instance, he said could, right? So he goes into this slippery slope uh, fallacy that if this legislation were constitutional, if, regarding the tax for those using child labor, then it would allow Congress to carve out other public interest areas and start to regulate them through tax, right? So he didn't address the issue of child labor, right? That was put before him, that Congress has already created this tax, this excise tax that it's authorized to do for companies, who use child labor, right? He didn't address that. It was something that was constitutional, and again, the ruling has been, he's the Bailey case. It was called Bailey versus Drexel Furniture Company in 1922. It was overruled by subsequent court cases, including Carragher, Marchetti, and of course, eventually Congress passed a law in 1938, the Fair Labor Standards Act, which prohibited child labor, expressly prohibited child labor. Now, regarding the reasoning of President Taft again, well, as Chief Justice, when he was saying, well, that Congress is trying to regulate uh, business by taxing, right? He was being inconsistent and he was being in denial of a power that Congress had been exercising already. Congress was already exercising that power. Now, I'll give an instance. Um, so, in fact, when I did my first constitutional law class in law school, I remember my constitutional law professor had said, "Well, one of the things that if the government doesn't like an activity, and that's a power it has, Congress, and they can just tax it out of existence." And he gave us the example of the KKK. That Congress wanted to get rid of the KKK, and so the KKK, in its second iteration, its second incarnation. Um, it's what Congress revoked its status as a tax exempt um, entity. It had registered as a fraternal organization in Georgia, and Congress revoked its status as the government revoked its status as a tax exempt entity, and they levied taxes on it, and it had a heavy tax lien of back taxes it hadn't paid at over $680,000, right? So it was owing all this money, and so basically it just had to go out of existence, right? So that's the power that Congress has. Congress did exercise this power, although it was in the 1940s, around 1944, when the KKK in Georgia owed all these back taxes, and it went out of business. Now, and there are other means, right? And I think that was what he was looking at. That, okay, why doesn't Congress just outright enact a law to abolish the activity if it doesn't want to, because Congress has the power to do that, right? Which they did in the 19th century. The first incarnation of the KKK, uh, Congress had actually created the Ku Klux Klan Acts, right, which allowed the government to use the military against it. This was under President Ulysses Grant, and so the U.S. military went against the KKK back then. And I guess this is what President Taft was looking at. That, well, if Congress doesn't want businesses to use child labor, why tax them for using child labor and make it look like a penalty? Thus, he was using the term scienter, that it was like a criminal penalty. But Congress does have the power to do that. And eventually that's what it did in 1938 through the Fair Labor Standards Act, which prohibited child labor. So I want to go deeper into some of President Howard Taft's cases as a Supreme Court Chief Justice. I wasn't impressed by his reasoning. Again, this was a clear instance of a slippery slope fallacy that, well, there'd be this chain reaction if Congress could do this. Well, Congress already had the power to do that, it had the authority to do that. And there was a history, instances when Congress had done that, right? It had regulated and it has the power to regulate commerce, right? Interstate and intrastate commerce, so long as it has a substantial effect on interstate commerce, right? And it has a stream of activity that affects interstate commerce. So, Congress already had the power to regulate commerce through the Commerce Clause. And Congress had exercised power to tax and and an invidious activity out of existence. And of course, child labor was an invidious act. The use of child labor was an invidious act. And it's just surprising that President Howard Taft didn't demonstrate the sort of conscientiousness or empathy that you'd expect, and humanity, having been a previous president. But to scorn and find child labor reprehensible. He didn't do that, but he upheld. Uh, he found the child labor tax of 1919 unconstitutional and ruled in favor of uh, the furniture company um, Drexel Drexel Furniture Company against the government. My name is Olurotimi Osha. I like talking about American presidents, and I also draw attention to color of law violations, pivoting on subordination of perjury and fraud on the courts in Montgomery County, Maryland, in order to obstruct justice. And my constitutional rights have been violated. And I've done videos discussing this at length. You can check them out on my YouTube channel and on my Facebook. And I've written about this as well, and I'll keep you posted. Thank you.